Now, there's been an important decision in the court related to online reviews. Rebecca Young is a partner at JMW Solicitors and is head of media and reputation management. So, Rebecca, what's happened in this decision?
Hi, Dom. So last week, the High Court handed down a judgment in an important case involving what are called Norwich Pharmacal Orders. The name given to NPOs, as we'll call them, is derived from the case, and it's where the court can, in certain circumstances, require a third party who is involved in the wrongdoing, but not actually the wrongdoer, to disclose information that will then enable the claimant to go on to pursue that wrongdoer in the legal claim, or it can also be other forms of redress. So NPOs are quite useful for online smear campaigns or tackling anonymous trolls. The decision is an important one, as it appears to be that the first time the court has been asked to look at this point of whether an email account provider can be forced to provide information where that email address is used to set up a false social media account that goes on to post allegedly defamatory or harmful content. So briefly, just the backgrounds of this case then, Dom. There were 6 claimants and they sought an NPO against Google, requiring Google to identify the individual or the individuals behind certain Google email accounts. And of the 6 claimants, 2 were corporate entities that operated a property management business and an estate agency, and the 4 individual claimants were members of the family-run business. The claimants wanted to bring claims in defamation and malicious falsehood, as they alleged that they and the business were the victims of these fake reviews, which had been posted by several people on the platform Trustpilot, which is one of these review platforms that we all know about and tend to go on to have a look before we use a service or purchase goods. So it was alleged that those reviews could be grouped by themes. So it was alleged that there were harmful allegations that were made that were false, defamatory, and that most of those reviews had been posted by accounts either that only had one single posting, which was this particular account in question, or they'd otherwise posted 1 or 2 posts on other businesses' profiles, and they were also only of 1 star.
And so the court did identify the Trustpilot accounts, didn't they? But not the Google accounts. Is that right?
Yes, Dom. So this was the second application that was brought before the High Court. The first application that was brought for an NPO, the claimants were successful in that application, and that was against Trustpilot. And what that enabled them to do was to identify the email addresses that were associated with the accounts that had posted the defamatory reviews. Now, those email accounts, they were all registered with Google. The test, just very briefly, as for an NPO, an application that you may make, is that you have to demonstrate that there has been a wrong carried out, or arguably a wrong carried out, by the ultimate wrongdoer. Secondly, that there must be a need or a necessity for the court to make the order to enable the claimant to take steps to enforce their legal rights. If there's another way to obtain that information, for instance, then the court's not going to grant that order. It doesn't have to just be for legal proceedings, as I mentioned at the outset. It can be if there's other forms of redress as well. And the final point, which is the one that was considered in some detail by the court here, is that the order that is sought must be against a respondent who has been mixed up in, has facilitated the wrongdoing, and they're likely to be able to provide that information to enable the claimant to ultimately pursue the ultimate wrongdoer in all of this. So that final point, one of facilitation, is what was considered in this case and what was important, Dom. So the respondent to the application has to be more than a mere witness. And what the judge did in this case is he undertook a very careful analysis about what role Google had in all of this. And Google provide the email address, and that facilitates the setting up of a Trustpilot account. But there's no wrongdoing in the setting up of the account. It's not until you go on to use the account and there's that secondary activity, Dom, that there is that potential wrongdoing. And in that, Google played no part. So that was the basis upon which, in this instance, they were unsuccessful in their NPO, because effectively, once a post is shared, Google are a mere witness.
And Rebecca, lots of businesses fall foul of these malicious reviews. How can you and the media and reputation management team help businesses?
So the decision is an important one, Dom, as far as I'm aware, it's the first case that's been reported where the courts have been asked to look at this particular decision. And notably in the judgment itself, it records that when the court was listing this application, it was listed before a judge as opposed to a master, which is normally what happens with an MPO application. So it is an important case, but it's important to note that MPOs are only sort of one tool that you have as a claimant to potentially identify those behind the anonymous accounts. There are other options that you can explore. There are orders which are known as Spartacus orders, and those are orders which require a defendant to identify themselves. It's also possible to obtain orders and damages against persons unknown. The court is constantly looking at different technology and keeping, up to date with that.
Rebecca, thank you for your insight. And if you'd like to contact Rebecca and the media and reputation management team here at JMW Solicitors, you can email insideman@jmw.co.uk or call 0161 82 81 999. Please also subscribe to the JMW Inside Man YouTube channel for the latest legal news, hints and tips. I'm Dominic Walker, JMW's Inside Man.